Hey everybody, this week we're going to look at the Bill of Rights and some history that led to the passage of Amendments 6 through 10. Probably the most important one to look at is Amendment 6 because it's about what happens at trial. And there is a long history of abuses throughout Europe, specifically in England, which also got brought over to the colonies, which caused problems at trial. Sometimes people were arrested, imprisoned, tortured, and even executed for things that they didn't do because the trials were held secretly. And the judges had no one to back them up, no witnesses to back them up, no juries to back them up. Evidence that was used was often unreliable or a little sketchy, frankly. Think about the spectral evidence used in the Salem witch trials. And while people were awaiting trial, they would sit in jail, either in England or the colonies, for months or years without having their cases heard. When the founders were adding the Bill of Rights, clearly an important series of protections was around what happens once you go to trial, once you're in court. And so now, Amendment 6 in particular outlines the things that you can expect once you get to trial. Number one, a speedy and public trial. Speedy because we don't want anybody waiting around too long for their case to be resolved, like months or years. And public so that there can be people outside of the proceedings be witness to what goes on in the proceedings to make sure that things are fair and just. Now, the fact is, the government can't guarantee a fair trial because in every trial, somebody wins and somebody loses. And guess what they'll say? This isn't fair. But to the extent that they can, the founders wanted to make sure that the process was in place to keep things as fair as possible and that justice was served. Another safeguard of Amendment 6 is having an impartial jury. Oftentimes, juries are made up of 12 people, and they are people from the community who hopefully can judge without a bias, without a prejudice, without a preconceived notion of what the defendant is or has done. Another element is that the proceedings in court must be close to home. If you are charged with a crime in Boston, for example, they shouldn't be creating proceedings out in Springfield because it might be difficult for you to get there. The next part is witnesses. You should be able to bring witnesses to support you, to say good things about you, to give some examples of when you did the right thing and what kind of an upstanding citizen you are. And you should also be able to look in the eye the person who is got something bad to say about you. Oftentimes, in the old days, people were not allowed to confront witnesses against them. And while sometimes today it's still the case, for example, if somebody had been terribly abused or it was a child who was speaking out against someone, that person might be protected. Overall, though, you get to confront witnesses against you. And finally, everyone gets a lawyer. Counsel is provided for anyone who would like it. Are you allowed to defend yourself in court? You absolutely are. But it is not great advice if somebody tells you to do that. It's always better to have someone helping you who's got some perspective and expertise in the law. The desire to put Amendment 7 into the Bill of Rights was based upon the fact that juries were often not considered if the case wasn't substantial enough. The folks in England and across Europe didn't want to waste people's time by hauling them in to be on a jury for a petty dispute, which is a reasonable assertion. What that translates today to, though, is that the $20 that they mention is pretty outdated. It seems like a short-sightedness of the founders to put that amount of money in. It says that $20 is the minimum that a court case must be worth, which translates to about $560 today. Instead, what this essentially establishes is that lower courts are going to handle smaller cases like this. Therefore, this particular amendment, number 7, doesn't really have a place in today's court. The framers of the Constitution were pretty clear on putting some careful guidelines in about cruel and unusual punishment. The Eighth Amendment was added to protect against torture, was added to protect against holding people in jail indefinitely, and imposing bail levels that were ridiculous, that people could never afford. Now, understand that bail is what the court will charge you if you want to leave jail while you're waiting for your trial to happen. And so they would say, you are being charged with bank robbery. We're going to ask you to give the court $10,000 for bail. The court will hold that $10,000 and you'll go home and wait your trial. When your trial comes, if you show up for the trial, we will give you back that $10,000 and we will see your trial through. Mostly, this is a way to make sure that you return for the trial. Today, criminal punishments are closely regulated. Bail guidelines are set by a standard, and so if I'm charged with bank robbery, there is a span of bail that the judge can assign, say from $8,000 to $20,000. And the judge is not allowed to go outside of those guidelines. Furthermore, torture of people being held awaiting trial is illegal in any way, including things like keeping food from people or drink from people, keeping them awake for too long. And finally, Amendment 8 protects against some pretty horrible practices from the old days, which was things like drawing and quartering, where they would have an animal, like a horse, drag you along the ground, and different horses would run in different directions with different parts of your body tied to them. Quartering your body up into different parts, in other words. And things like disemboweling, or cutting a slice in your lower abdomen so that your bowels fall out, or burning someone alive. Those are no longer allowed to be used, even if you are subjected to the death penalty, thankfully. Finally, bail is allowed to be not used if the judge thinks that someone is going to be a danger to society while he or she is awaiting trial. Now, in what most people consider to be a brilliant forethought by the founders, they added Amendments 9 and 10 to the Constitution. Amendment 9 is people's rights. There were so many people who lost rights while they were awaiting trial or during trial or while they were being held. And the founders realized that with new ideas, new inventions, new technologies, they might not be able to protect against all of these problems. And so they said, anything else not granted as a protection here in the Bill of Rights or in the rest of the Constitution may be added if it's appropriate. It's kind of like stretching the bounds of the Constitution for the people. What this translates to today is that the people have been given extended rights beyond what's been written in the Constitution, and it largely focuses on privacy. An example in our current day is internet regulations. Since the internet is reasonably new, the protections and privacies that we get on the internet are kind of being decided right now to see how they fit into the people's protections and people's rights. And finally, number 10, the last of the Bill of Rights, was an opportunity for the founders to grant additional rights to states. Rights that either were not mentioned in the Constitution already, or rights that were not given to the federal government or restricted from the state governments in the document. The colonies had been kind of on their own up against the king, and so people realized that they were going to need special protections. It was another way of federalism empowering the states. And so what this translates to today is whatever rights are not already given to the federal government or not forbidden to the state governments can then be taken by the states. An example from several years ago was marriage. States were able to determine ages and licenses for marriage, including whether there was a legality to gay marriage. The federal government took that over by passing a national law allowing gay marriage all across the United States. However, right now we have a great example of states' rights. We've got a quarantine going on, and it's up to the governors to decide whether people need to wear masks, whether people are allowed to go back to work, who's considered an essential and a non-essential worker. So this is perfectly pitched to what we're all living through today. So I hope you've enjoyed this history of where the Amendments 6 through 10 came from. Ultimately, personal protections were very important to the framers of the Constitution, and their unfortunate circumstances, the challenges they faced in England and the colonies, leads to all of our benefits today for the protections they left for us in the Bill of Rights.